All right. They were to discuss courts with criminal jurisdiction and the issue of criminal jurisdiction. So it's a very straightforward question. But talking about courts with criminal jurisdiction, basically, apart from the appellate courts like Court of Appeal, Supreme Court, you can say that every court has criminal jurisdiction. Every court has criminal jurisdiction. But at the Federal High Court, the creation of the court is section 250, but the issue of jurisdiction, power to exercise criminal jurisdiction, we can look at this right down from section 251. When you look at section 251 down, you discover that there are matters within exclusive legislative lists. The matters of jurisdiction conferred on these courts are matters of exclusive legislative list. Section 251, subsection 1s, it states, such other jurisdictions, civil or criminal, and whether to the exclusion of any other court or not, as may be conferred upon it by act of national assembly. So this one is, for instance, what we call futuristic jurisdiction. So this one has not happened. It's just the power on National Assembly. Say, just in case National Assembly makes any law after we have passed this one now, that law should do what? Should stand. If National Assembly makes any law conferring jurisdiction either on civil issues or criminal issues on the Federal High Court, then that law becomes valid by virtue of section 251, subsection S. Look at the proviso. Provided that nothing in the provisions of paragraphs B, Q, and R of this subsection shall prevent a person from seeking redress against the federal government or any other of its agencies in action for damages. So this one is still pertaining to what? To the civil aspect of it. And now sub 2, section 251, subsection 2 says, the Federal High Court shall have and exercise jurisdiction and powers in respect of treason, treasonable felony, and allied offenses. Federal High Court shall have and exercise jurisdiction. So from here now, I expected you to pick up an issue here. First of all, a jurisdiction has been conferred on the Federal High Court by virtue of this provision on the issue of what? Treason, treasonable felony, and related offenses, offenses that are related to these major offenses stated here. And then you ask yourself, what type of jurisdiction is this? Is it exclusive or not? So when you look at the letters of this word, it says the High Court shall have and exercise jurisdiction, simplicity. It didn't say exclusive. It didn't say exclusive. So now, when you look at maybe provision of the old constitution that has been interpreted alongside this a similar provision, a provision that looks alike to this, which stipulated that this thing here, the jurisdiction here is exclusive. And then you just oppose that provision with this very one. If they are not the same, then it becomes an issue. It becomes an issue whether that law is still good law or not. Are you following what I'm saying? Yes, because you will see some cases that will tell you that the offenses of treason and treasonable felony can only be done where, can only be entertained where? At the Federal High Court. But is this provision talking about exclusive jurisdiction? Right, it may not be here, okay? But we also look at other provisions containing, let's go back to section 251 now, to see if a mention is made. We're doing interpretation of statute now. 251 sub 1. Notwithstanding anything to the contrary contained in the Constitution, and in addition to such other jurisdiction as may be conferred upon it by an act of National Assembly, the Federal High Court shall have and exercise jurisdiction to the exclusion of any other court in civil causes and matters. Are you following me? In civil causes and matters. So, subsection 1 here is telling us that the exclusive jurisdiction is on what? Civil matters. Now, any other thing again, and then it starts itemizing what and what the things that should be there. So, those are the issues I had wanted people to look at. Now, sub 3. Let's see if sub 3 has anything to do on the alteration provision, whether it can give us any clue. Sub 3 says, the Federal High Court shall also have and exercise jurisdiction and powers in respect of criminal causes and matters, in respect of which jurisdiction is conferred by subsection 1. So what do you make out of this? Is it now telling us that the jurisdiction here is exclusive or not? What do you think? Because sub 3 said the Federal High Court shall have and exercise jurisdiction and powers in respect of criminal causes and matters, in respect of which jurisdiction is conferred by subsection 1 of this section. It's not telling us that those exclusive jurisdictions on civil matters given to Federal High Court. The Federal High Court can also do what? Exercise jurisdiction in criminal aspects of them. But being silent on the word exclusive. Issues I had wanted you to bring down. One, the issues of the areas of jurisdiction. You now see when you apply your tenets of interpretation. What rule do you apply here now? Purportive. What is purportive? Explain purportive.
The purportive rule of interpretation is more profound when we're interpreting the Constitution in our own law. So they said the idea I have about it is that you look at the purpose of the Constitution. What was the intention of the draftsmen when they imputed that section? What was the purpose that section was put there to achieve? So when you want to do this, they said you should read the whole section.
So you see, since you were not there, what do you think is their purpose? So you can only bring a bit of speculation when you apply the correct law. Like here I said, purposive. Right. Any other terms of interpretation that may also suit. I agree with you. Because when you talk about purpose, the purposive rule of interpretation, that rule simply means look at the purpose. The idea behind this provision is to make sure that Federal High Court is what? A specialist court. A court with what? Exclusive jurisdiction in these areas. Why? Because the areas being talked about are areas that are within the exclusive legislative list. The area that is only the National Assembly, not the state. Only the National Assembly can have the legislative competence to talk on. So we can say that their purpose is to make everything under this provision, to bring it within the exclusive jurisdiction of what? The Federal High Court, whether civil or criminal. Because if you use the literal rule of interpretation, it may mostly do what? It will run riot. Let's look at the jurisdiction of the High Court. Section 272 is on State High Court. And it says, subject to the provisions of Section 251. Are we making any headway? Are you listening to me? Subject to the provisions of Section 251 and other provisions of this Constitution. The High Court of a state shall have jurisdiction to hear and determine civil proceedings in which the existence of blah 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 blah, just mention all those things are concerned. Sub 2 says, 272 sub 2, the reference to civil or criminal proceedings in this section includes reference to the proceedings which originate in the High Court of a state and those that are brought to the High Court. So, the same interpretation that we use here can also be applied to Section 251. Do you understand what I'm saying? It's simply saying, High Court, remove everything under Section 251, take the rest. Are you following? That's just the easiest way for you to understand that. Subject to the provision of 251. So close your eyes, forget about 251. So anything in 251 is not your business. But the rest, take. Are you following? So that's just that purposive approach. And when you also adopt what we call the community reading of the entire statute, you discover that most of the time for a provision of a law to make sense, you have to do what? Approach it holistically. So by so doing, you discover that what might have been a conflict is that was not a conflict, but it's an issue of law that we have to discuss and become acquainted with it. I'm looking at the course you didn't mention. You didn't mention Sharia Court of Appeal. Sharia Court of Appeal, let's look at the kind of jurisdiction they have, whether they have anything to do with criminal jurisdiction, especially in respect of Islamic personal law. Section 2771, the Sharia Court of Appeal of a state shall, in addition to such other jurisdiction that may be conferred upon it by the law of the state, exercise such appellate and supervisory jurisdiction in civil proceedings involving questions of Islamic personal law, which the court is competent to decide in accordance with the provisions of subsection 2. Which says, for the purpose of this section, the Sharia Court of Appeal shall be competent to decide, and then it starts to list everything here. And when you look at most of these things it's talking about here, you discover that the personal law in question here are basically issues that have to do with civil. They are basically issues that have to do with civil. So that means we have removed this court. What about area court? You didn't discuss area court. I'm talking to that group. You didn't mention area court. Does an area court have criminal jurisdiction? Area courts are like magistrate courts in the south. Right. We are talking about courts with criminal jurisdiction. So I expect you to have mentioned that. So area courts do have criminal jurisdiction. Now, but in terms of appeal, where does appeal lie from area court? Where does appeal lie? So we're making progress. Okay, so that's our specific areas we didn't touch. Let's get the jurisdiction, call the provision and the jurisdiction of Natural Industrial Court.
254C, that's the third operation.
Okay.
Yes. It says that it shall have such other jurisdiction, civil or criminal, and whether to the exclusion of any other court or not, as may be conferred upon it by an act of the national.
So presently none. It's also future. So you also have to have mentioned it. All right. Then it's one of the issues. Now, if the law, if the Constitution had deemed it wise to tell the Federal High Court or to confer criminal jurisdiction in respect of civil matters being handled by Federal High Court, why did the Constitution not do the same thing to National Industrial Court? What are the jurisdiction, the civil jurisdiction as scope of the National Industrial Court, so that you will understand a bit of what I'm talking about? Labor. Can there be any crime emanating from operation of labor? Yes. Go ahead, be reading. So let's just be looking at them.
Relating to connected with Factories Act, Premises Act.
Okay.
Then relating to or connected with a grant of any order, restraining any person or body.
Okay, like when an order restrains you and you disobey, it becomes a criminal offense. Go ahead.
Then connected with any dispute over the interpretation and application of that chapter 4 of the Constitution.
Okay.
Then relating to any disputes arising from national minimum wage.
Okay. Now, also, if maybe there's a dispute arising from national minimum wage, and labor, in the process of protest, shuts down the national grid, would that not be taken as an economic sabotage? Good. So I just looked at some of these provisions so that you understand my argument. if the Constitution had donated criminal jurisdiction to Federal High Court, why not do so to National Industrial Court in such specific terms, in addition to futuristic jurisdiction? All right, so we'll look at other issues that one can garner from the criminal litigation in relation to jurisdiction. Is what we can look at. This is Federal Act. I was thinking you're going to show me Abia State one, because there is a variation, especially when you look at in terms of section 93 to 103. For instance, you have when offense is committed at sea or outside of Nigeria. It's an issue you have to also discuss, because she tried to say that the court have come to find out how to resolve the issue. For instance, this very one, the offense that is committed at sea, maybe at that portion of the sea where the ship is not within the jurisdiction or the nativity of the ship. You know, a ship is like a citizen. It has a citizen, it belongs to a country. It has nativity. Now, if a ship is found on the high seas and a crime is committed, where would you charge the offense? Those are some of the criminal. So it's not something we speculate, but it's not something we do what? We look at the statute and see how to resolve it. By the Federal Administration of Criminal Justice Act 2015, you look at section 94, how it has resolved it, especially when an offense has been committed outside Nigeria. So we'll quickly run through some of them for proper understanding. For instance, let me start with section. It's very copious, but we just look at some of them. Section 93. An offense shall ordinarily be inquired into and tried by a court within the local limits of whose jurisdiction the offense was committed. You know, as a general rule, the general rule is what? That the court that has jurisdiction is the court within which jurisdiction the offense was. So, but when an offense is committed partly in one jurisdiction and partly in another jurisdiction, we don't have to speculate. We do what? We look for it in the letters of the law and find out. So if you look at that of Abia State, you also find out as it relates to state offenses. Now again, it says where, for instance, where it is the offense was wholly or in part committed, or some act forming part of the offense was done. So this one is saying that if, for instance, it can be determined where particularly an offense was committed, it can be charged the court within the jurisdiction where the offense was completed will have jurisdiction, as well as the court where they started, the jurisdiction where the offense started. Assuming it's robbery, you understand? Let's say night boss has left FCT and armed robbers were there. They robbed those, they continue robbing the passengers there. When they got to Lokoja, they also robbed. They came into Enugu, the same thing. That they came into Enugu State. When they entered into Imo State, they said just the same thing. And then, if finally these criminals were apprehended, where do you charge them to? Right. So any of these locations they pass through, we have jurisdiction to do what? To charge and entertain the criminal act. But the issue will be, what if one particular jurisdiction is already seized with the matter? What if one particular location is already trying the matter? What happens to the other ones? Right? Are you following this? So what they simply have to do is to do what? To allow the court that has already started trying them to do what? To continue. Right? Because there is nothing like try them partially here, bring them to another jurisdiction until it is completed. No. Again, too, the consequence of the offense, where the consequence of the offense has ensued. So maybe somebody was robbed at Lokoja, and he arrives at Abia State. where he now begins to feel the consequence of the offense. How can he feel the consequence of the offense in other states? Can I have some contribution? Did you understand what I'm saying? Yes. Offense was committed in another jurisdiction, but the consequence was felt in another jurisdiction. How can the consequence be felt in another jurisdiction? Somebody who was shot at Lokoja, sustained injury, maybe mortal injury, he gets to Abia and dies. At Lokoja, there was no murder. Am I right? Yes. At Abia, there was murder. That's the consequence. And another way is like maybe you're bringing goods, and they stole the thing the person was bringing, and then along the road, it says, stupid driver, go, we're jumping down, they got down somewhere, and then you arrive at Abia stage. You need to account to your boss. What is the consequence now? What is the consequence? That you have arrived empty-handed. You understand? A person against whom or property in respect of which the offense was committed is found, having been transported there by the suspect or by a person, just like when somebody is charged with receiving stolen property. These goods might have been stolen in Lokoja, and then it's traced at where? Lagos. So the person you have seen holding the goods, you do what? You arrest him there. And then try both the offense of stealing and receiving of stolen property there and then. Do you understand? Good. So that whichever one catches the person. And what are the ingredients of receiving stolen property? I'll just encourage you to look at these provisions. It has provision for offense committed. I'll look at the offense committed outside Nigeria. Offense committed in the course of a journey. Offense committed in different places. You also have them from sections 94, 95, and 96. So what are the elements of receiving stolen property? What are the elements? Knowledge. What again? Knowledge of what?
That the property is stolen.
That the property
is stolen.
How do you, what if the person doesn't have knowledge? Can the person still be convicted if he doesn't have knowledge? First answering. So why did you say yes?
The person can be convicted, no?
Yes.
For instance, depending on where he bought these goods.
Okay.
So if you are buying the goods and it's not in a market spot, and you are claiming that you don't have knowledge that it was stolen,
okay,
both the price they are getting the goods and the location you bought the goods is saying otherwise, then the person can still be convicted.
Location and what again? Because if I'm a trader, maybe I have bought what they call our, all those contraband. You already know me as a trader in that group, so I can sell it to you at any location. Not to talk of these days, you can send a Uber rider to bring it, so long as it's not slap. Then you're making sense, but there is one note I want you to tie there. Right? You're talking about somebody you know sells this or that goods. So whether it's genuine or not, he has sold to you in a different location. The fact that he didn't sell to me in market over does not necessarily mean that knowledge will be imputed to me. There is something that will make knowledge to be imputed to me. What is it? You simply say the price. That's where market over comes in. And so long as it is unreasonably below the price at the market over, then there is what? Knowledge. Knowledge will not be imputed on the person. All right, so any question? Right.
And what is this person? The person that is saying is to say that he just wants to sell because he needed the money urgently.
That he needed money urgently. Now, have you forgotten circumstantial evidence? Don't forget it now. You've already learned it. If the person, that's his own defense. I saw this so because I needed money urgently. Right. And then this person selling to you, what is his source? Where did you get it from? You have to trace it. There has to be a link. And then finally we discover he bought from an apprentice who doesn't have shop anywhere, who has stolen it from his organ to sell to him. Right. That's where the problem starts now. Okay. Any further question? All right. See you next time.